Welcome to ACM's Board Member Basics Orientation and Refresher. We appreciate everyone joining us, stepping away from your families on a Saturday morning. We promise to give you an information-packed session. We'll try not to overload you all with information, but we have an all-star group of presenters today. And so once again, we thank you. So ACM just celebrated a 20-year anniversary. We were started in 2001 by our founders, Mel and Peggy Hertzberger, and we are elated to still be servicing communities across the state of Maryland and now in DC and Virginia. So first, before we jump into our presentation, I would like to introduce our key guest, Attorney Craig Zaller with Nagle Zaller. He is an awesome, dynamic. He doesn't need me to, highlight him, but you're going to get so much information today for those who are new board members as well as those who are here for a refresher. We also want to just highlight a couple of members of our staff. They're off screen, but Heather Griffin, our Chief Operating Officer, will be presenting. We have Gisela Deering, our Director of Community Management, and many others who will be joining us today to speak with you. We really appreciate you. And last but certainly not least, I would like to thank all of our volunteer board members, yourselves, for the excellent work that you all do in your communities. So we're going to have an HOA Condo Act Overview from Craig Zaller, Esquire Managing Partner with Nagle Zaller PC. Thank you, Craig, for joining us this morning. Take it away.
All right. Well, good morning, everybody. First of all, I want to thank you all for joining us on this beautiful Saturday morning. And Theresa, thanks for the nice introduction. It's always great to work with the ACM team. So Theresa and I talked, and she asked me to come talk today, basically for a new board refresher orientation. And we talked about a couple topics, and Theresa asked me to talk about the topics in your outline. It looks like there's three big points, and I'm handling the first, part, I should say, of this morning. And I'm going to hit the main topics that are in the outline that all of you should have by now. By the way, those in the audience, I believe you were all emailed copies of the outline that everybody's going to have here today. And I'm basically going to be talking about governing documents, the statutes, the hierarchy, and amending governing documents and general issues. Also been asked to talk about meetings, budgets, collections, and I wasn't asked to talk about this, but I added new laws because just yesterday I read all of the new laws that just passed in the past legislative session, and I think three of them are extremely interesting and worth talking about. Usually every year I will draft a newsletter to all of our clients explaining the new laws, so I haven't done that yet. Half the people in my office don't even know about this yet, so you're going to get the first shot at three new cutting-edge laws that I think are really cool, and they're going to affect our industry. Big picture of those. I see some clients in the audience. I know there's some watching. I've been practicing community association law for almost 30 years now. Represent 700 plus communities. I live and breathe communities. So I'm going to try to educate you. We can have a Q&A throughout. By the way, I don't like to just lecture. I like to talk and have interaction. But keep in mind, I'm just giving general advice. So if any of you have particular issues with your community, you can ask your questions, but I don't want to go on a tangent for a half hour about your issue. If you want to talk about that, we can talk about that later or another day. So with that being said, let's talk about part A in my outline, which is the first big topic and the largest, to be frank. And by the way, when I teach a lot for the Community Associations Institute, CAI, and a lot of times I teach each of these topics like 3 hours in the morning, and I'm covering like 2 of those plus some more. And I got about an hour and a half max at my part 1. So I got a lot to cover. So I'm going to try to go a little swifter than I normally do. But if I go too fast, slow me down. And we'll take it from there. So I'm putting Heather and Theresa in charge. Or you, what's your name, ma'am? Peggy? So go like that if I go too fast, because I'm a pretty wired guy. All right, so the first thing I'd like to just talk about is just the basic concept and understanding the documents, the statutes, and what you're supposed to do, and what your job is. Because I presume, by the way, I'm going to talk to mainly people in the audience because I can see you. Obviously, the video people can see me. But are you all board members?
Yeah.
How many of you are new board members? Okay, we got about 5 new boards. And all the rest of you, how long have you been board members? More than 5 years? One more than five. I recognize you, by the way. I can't remember which community, but all right. More than five? Less than five? Okay. All right, well, let's go big picture. All right, so what is your job? And your job and why we have covenants and declaration and bylaws, why are they there? They're to preserve, protect, and enhance your property values, to regulate the behavior and the use of the properties, and to protect the health and safety of your owners. That's really the big picture in what your job is and why we have community associations. With that in mind, number 2 in the outline is critical, and it's very difficult because there's a lot of new board members, there's a lot to cover, and this doesn't come natural to a lot of people. And sometimes you might get asked a question and you look at the governing documents for an answer, but the governing documents don't give you the answer because it's been outdated by other laws. So it's really important to understand all of the law that could be applicable and the hierarchy of it, and to know when you need to go to your manager or your attorney or your accountant or whatever it is to get the advice you need to do what you have to do to deal with whatever situations before your community. So I start off by listing the statutes, and it's interesting, you'll note I put in parentheticals sometimes, because sometimes the statutes control and sometimes they don't. And I'll give you a couple, I don't even need to look at the book. I'll give you just a couple examples. In the Condominium Act, there's a statute dealing with fining, and it says, unless your documents state otherwise, you have to follow the following. But if your documents do state the other way, you have to follow those. There are statutes regarding open and closed meetings. Your documents, unless they are new, state the old open and closed meeting laws. So if you were to look at what you were allowed to close your meeting for, you would get the wrong answer. There are a lot of other statutes out there. There's new laws on fidelity bonds, basketball hoops, solar panels, American flags. I can just rattle this stuff off. All those things override your governing documents, whether you want to allow those things or not. People don't want clotheslines, but there's a clothesline statute that allows you to have clotheslines. People don't want to allow solar panels on their homes because they're ugly on the roofs, but there's green statutes that allow people to have the solar panels. So there's a lot of laws that override the documents and that prevent the board from doing some of the things they might want to do. And most importantly, the statutes can override the documents, and you need to know what the law really is to answer the questions that come up with your homeowners. So that's a critical issue, and I'll give some more examples later, but I just want to get the big picture out there. Then sometimes your declaration's controlling, which I listed as, Sec 2D. What is a declaration? So for HOAs, a declaration defines the common areas and the lots in a homeowners association, but in a condo, it serves a lot of other purposes. It defines the common elements, the limited common elements, and the units themselves. And what you also have to understand is it cannot contradict a controlling statute, but it can in a statute that's not controlling, where you have a choice sometimes. The bylaws pertain to the administration and management of the community, and they also cannot contradict the declaration or the statutes. You must also understand big picture. The declaration's your controlling document, HOA or condo. Bylaws are next, and then rules and regs in that order. And they cannot contradict anything in that order. So your rules and regs can't contradict bylaws, and your bylaws can't contradict your declaration. Sometimes the statutes override, sometimes they don't. The rules and regs under sub D clarify and expand upon the provisions of the declaration and the bylaws. And generally speaking, something that's huge and important for you to understand is that you can make a rule, boards, on your own in general, as long as you follow the due process procedures and the statutes, and you don't have to get a vote of the owners, which is critical as well, because if any of you have tried to amend, which I'm going to talk about later, it's not exactly an easy task. So that's good to know that the board has that power.
Can I ask a quick question?
Of course you can.
So you said that statutes sometimes can override and sometimes they cannot
Yes.
override? How do we determine when a statute overrides versus does not override one of these other?
Okay, so for everybody on the camera, I don't know if you could hear his question, but he's basically saying, how do you know when a statute overrides and you follow the statute versus the governing documents? The statute answers that question. So, again, I'll just stick with 11.113 for a moment, because I know it's an easy one. It says, unless the declaration or bylaws state otherwise, you do the following. Versus, let's just take the closed meeting statute, 11.109.1. You know, a board meeting may be held in closed session only for the following purposes. It's clear that that's it. There can be no other exception. Your documents, if they're older, will have part of an old statute which allow boards to close a meeting upon a 2/3 vote for basically any reason they thought was appropriate. But what you had back then, and I was practicing then, is you'd have boards that were not exactly kosher, shall I say, closing meetings to do whatever they wanted and excluding the owners from having a say. And the big concept is due process to all of the owners, giving them their ability to talk, but yet still allowing the board to make a decision. Because generally speaking, you board members, you do everything other than 4 main points. I'm a little off topic, but I do that a lot, but it's important to teach you. You owners have 4 basic rights. The right to amend the declaration, to vote on that, I should say. The vote to amend the bylaws, the vote to appoint you board members, and the right to remove you board members if you're bad. Generally speaking, that's it. Every community across the state, condo, HOA, co-op, all have those 4 rights. There are a few other rights that some owners have in some communities, depending upon their documents. Nothing statutory, but in your various documents for your communities, the owners might have the right to vote on a special assessment. Sometimes they have a right to vote on a piece of litigation. Sometimes if you spend a certain amount of money. But other than those topics, generally speaking, you all have a fiduciary duty to do your job and to do everything I talked about in Part 1, A, B, and C. That's what your job is, to enforce those covenants and to preserve and protect and look out for the best interests of the community and all your property values. Usually the biggest investment everybody has in their life. So does that help answer that question? And there's like, you know, a litany of statutes, and if anybody ever wanted to Google it, it's not hard to find. The Condo Act is 11.101 of the Real Property Code, and the HOA Act starts with 11B.101 of the Real Property Code. Condo Act is much more inclusive, big picture, like 35 statutes. HOA Act's about 15, 20 max, much smaller body of law because it's not near as convoluted as a structure where everybody's sharing in the ownership interest in the building versus just owning your individual townhome or a single family home.
Quick question?
Yes.
Several times in both the condo and the HOA, it says reasonable. When it talks, you can do this instead of 10 days, you can do it in a reasonable amount of time. It's subject to interpretation.
So if any document says in the reasonable discretion of the board or anything like that, then it's just reasonable. And ultimately, a board does what they think is fair, and it's only deemed unreasonable if somebody's challenging it. And at the end of the day, a judge or the attorney general makes a decision. So that's where you got to go to your experts, your experienced managers, or an attorney like me, or whatever attorney you're working with. And if you have an issue, you got to talk to them about it. That's a big picture too. Use your experts. Don't think you know everything. Go to your accountant when you need your accountant. Go to your manager when you need your manager. Go to your lawyer when you need your manager, your engineer for your experts, whatever it is. You're all not experts, and even if you are, by the way, be very careful if you're on your board trying to give advice yourself. Dangerous. Number 3 is a little somewhat off base, generally speaking. I really wrote number 3 dealing with covenant enforcements and enforcement issues overall and who does it, but I'm going to tie it into everything we're talking about. So again, the board has the power to do everything. So can I pick on you throughout the class, Peggy? Because you're right in front. So Peggy puts up a fence without permission. Who's the one who's going to enforce against Peggy? It's going to be the board, not the owners. The owner can complain Peggy did something or put up the fence, but the board's the one who's going to enforce. But there are some times when you have situations where there can be an owner-to-owner dispute, and the board might think that's petty between the two of them, and they'll step back and say, we're not enforcing, that's between you two to fight. And then sometimes there's federal, state, and local laws that come into play in this whole issue. I don't want to go too off on covenant enforcements because I really wasn't asked to talk about that today, but it gets to the bigger picture of who's doing the job relating to Roman numeral 1 and 2, and who are the people that are supposed to address all these issues. And again, it's the board. You do everything, and you need the help of your experts to do it. let me see if there's anything I want to talk about in Roman A, in section A. Does anybody have, I know I ripped through that a lot, but I could talk for hours, so I don't know where you guys want me to focus. Are there any questions from the audience before I go on that? Or Heather, from the owners, are you taking chat questions?
Feel free to talk about covenant support, that's totally fine.
I can come back to a lot of topics, but let me at least try to get through this, and then we
Yeah.
can, so I'll make a note to come back to covenant enforcements. I mean, I teach a 3-hour class on that, so. No questions? Okay, so if not, I'm gonna move on to Roman numeral 4, which is still part of topic A, by the way. I apologize. Page 2, so I got lost for a minute. So what happens if your community has a statute where, like the one, let's stick with the same one. Your documents do state otherwise, and the provisions on enforcement are horrible. What do you do? Well, you can fix it. There's always a fix to everything, by the way. You can amend. Most of you, if you don't know this, look at your governing documents, and if it's a condo, you'll see they say you amended a 66 2/3 vote, where HOAs are usually 75 or 80%. But if any more experienced board members are out there by now, you probably know there's a new statute that came out, again, back to the statutory issue, an overriding statute that now says you can amend your declaration or bylaws for an HOA by a 60% vote of the eligible owners. Condos are 60% now for their bylaws, which is where almost everything is, as we talked. Actually, I didn't cover that exactly. Use restrictions in general that tell you what you can and can't do with your property are usually in the bylaws for a condo, in the declaration for an HOA. So in the bylaws for an condo, you can amend it a 60% vote, but it's still 80 for the declaration. Other than, little side tangent, the new statute that came out, most of you know about, regarding the revocation of rights to take away the right of somebody to use the pool, the parking lot, the tot lot, the tennis court, whatever it is, if they're delinquent now, that has to be in the declaration for a condo based on a case that I helped with that went to the Court of Appeals and then back down by statute because our lobbyists and our industry didn't like that ruling, so we got it fixed by a statute. So again, another weird example, back to your question in the back, sometimes you can have a ruling by the court and then a statute override that ruling later. It didn't really override it, it fixed the outcome, should I say. So you can amend the declaration or bylaws, HOA or condo, and then sometimes you can have situations where, I'm trying to think of one I just had the other day, where you don't really have an answer about something in the documents and you want to fix the problem, but you don't have to amend, so there's nothing in your declaration or bylaws on it. So you can make a rule about it, and you can extrapolate on your declaration and bylaws and set up a rule that the board can adopt themselves to clarify how to deal with that issue. So that's a really cool tool as well. So big picture, what I'm trying to get you to realize, if you're stuck with a problem, you can fix it, go to your managers, go to your attorneys, it can be done. I will tell you, amending can be difficult depending upon your community though. So I lived in a townhome community, the first real property I owned, and by the way, I was on my board. By the way, I sued my own developer. It was a pain. Don't ever be an attorney and on the board in your own community. I can tell you that from my own experience. But in any event.
Can I ask another quick question?
Yes.
So on this topic, is there a resource that we can go to that has, that provides best practice, up-to-date examples of rules?
I would say if you're here, you're probably on a board in a community managed by American Community Management. I would ask them to give you samples of rules and regs from other communities that have cool board members that would allow them to do that. I unfortunately can't give you other clients' work, so if I have client A asking for sample rules and regs for client B, I politely tell them I can't do that, but go to the manager that we both work with and they can give you other samples. I also suggest anybody here or in the audience join the Community Associations Institute if you have not already. It is an amazing organization. I'm the past president of the Chesapeake chapter a long time ago. I teach. They have a lot of other great attorneys, managers, engineers, everybody in the industry who helps people learn and do exactly what I'm doing with you now, but for a broader crew of people. And I imagine you can Google and find some sample rules for community associations. Most of our clients have websites now. Some allow access to anybody, some don't. I don't know if anybody in the management team has any other suggestions to that question.
We can provide samples.
ACM says they can provide you
Contact your
samples.
manager.
Contact your manager. My general issues, by the way, it's funny, Theresa asked me to teach, so I looked at a bunch of different outlines that I've taught, and I tried to pull together little pieces from all of them. So part 5 is actually part of my covenant enforcement class too, so we're tying it all together, Theresa.
Great.
So we're moving on to part 5. I live in an association for kind of council where we can't even meet quorum for annual meetings, so like are there ways to get around?
So let me hear you, you're saying you haven't reached quorum for annual meetings?
We haven't reached quorum for our annual meetings, I'm just, if we needed to amend, are there ways?
So this is a great question. He's saying basically that he can't reach quorum at his annual meeting, so are there ways to amend to deal with that issue? So fortunately enough, you don't have to amend because there's new statutes that are on that exact issue that override this whole topic. So I'm pretty sure I got this right. So 11109 of the Condominium Act was amended to allow if you don't have a quorum at your first meeting and you have proper notice after that, whoever shows up at the next meeting is deemed a quorum. The HOA Act was just amended similarly to mirror what the Condo Act has already previously done and was amended lately too. So the HOA Act also allows you to, it was last year's law. It's a similar same thing. If you don't have a quorum at the first meeting, you give notice at the next meeting and it's deemed a quorum. And now it just changed so that you have to give notice of the first and the second together, but you don't have to amend. And your manager will tell you how to do what I'm talking about. It's in the new virtual meeting statute, but unfortunately, I can't believe I did this. I thought of this last night after I got home. I brought the new laws for 2022, not the ones for 2021, so I don't have that exact statute with me. But you don't have to amend is the answer, and no quorum first meeting, quorum second if you follow your proper procedures in the statute.
Right, so that we're up to date on, but like if we needed to amend the bylaws or the declaration, like
Oh, you mean you don't have a quorum or people show up at the meeting, and how do you do it?
right.
Ah, okay. So he's not really asking about quorum, he's asking how do you really get the vote? Really what you're asking, right? So they don't all have to be at the meeting. All you need to get is that 60% at some point in time. It doesn't have to be at that meeting.
Okay.
So that's very common. So where I was going was with my own community. It was a 67 home townhome, which actually ACM still manages. And we walked around the neighborhood and we got it passed in 2 weekends because we were new, it was a new community, just came out of developer control. On the other hand, I've got 500 home communities in Baltimore County that took 5 years to pass documents. And then I have some that pass at 2 meetings, some at 6 months, some at a year. I had a meeting, I rarely work on weekends, but last Saturday I had a Deep Creek property meeting and they passed it at that meeting because all the people were there for the weekend. So let's just say you call a special meeting with your attorney and you get 25 people to show up and you need 75 to hit that 60%. So you take your 25 votes and you got them, and then you got to get people that are willing to help, committee members or board members, and if it's a high rise you can have floor captains, if it's a townhome you can have row captains, street captains for the single family homes, and you can go door to door and get the consent form signed. And then when you finally get that 60% vote, tally it at an open meeting and the board can sign the documents. Keep in mind that vote can change, by the way, based on time. If people die, people sell, people buy, you lose those votes. People can be delinquent, then get back to non-delinquency and you can count their vote, or they can be in good terms and then become delinquent. I forgot to mention, 90 days delinquent or more and you are not eligible to vote under that new statute. Yes, sir.
You mentioned changing, votes may change. Can a person who did vote one way before it was final change their vote?
For an amendment, yes, not for an election. Yes, but after the meeting occurs, they can for an amendment, but if the election occurred, you can't change it. And if it's an election issue, you can change your vote up until the election is held. So if you have a proxy issue, the last proxy counts. Sometimes you'll have issues where somebody walked around and got everybody to vote for them, and then people find out that that person was lying and full of it, and then they'll change their vote later, and we'll count the latter one. A lot of different things in play. I'm hitting on a lot of topics. But all good questions, keep them coming. Back to covenant enforcement. And this is somewhat applicable to a lot of issues, and I'll just touch on them. So with covenant enforcements, never selectively enforce. Let's just say we like Teresa and we don't like Peggy. And Teresa's got a purple shed and Peggy's got a purple shed. You better go after both purple sheds together. You can't just go after Peggy because you like Teresa. And this goes the same, by the way, broad stroke for collection issues. We'll just take an example, or anything else for that matter. If Teresa and Peggy are both in the same financial situation and Peggy's a jerk, and Teresa asked to have her late fees and interest waived, and so does Peggy, well, I'd probably waive the late fees and interest for both. Don't treat people different. Treat anybody similarly situated the same. You do not want to be accused of selective enforcement. It's the biggest problem I have in any counterclaim on a covenant enforcement case that I have. Don't abandon your covenants. So you'll have somebody put up, I always tell this story when I teach, like, had this community in Carroll County where a guy had his RV, and most of your documents don't allow big RVs in your communities, right? So we wrote a letter. Unfortunately, their documents didn't have fining, which I'll get to in a minute, so the only option was to go to court. All of you know, nobody can hide it. Any attorney you work with, we're all expensive. Nobody wants to spend money on us. So my answer to them was, well, they're like, well, what can you do? And my answer is, well, I have to go file an injunction to get the recreational vehicle removed. Well, what is that going to cost, Craig? And then I have to hedge and tell them, well, I don't really know. It could be this, it could be that. They could dig in their heels. It could be this. Who knows? So they decide they don't want to do anything. And then I say, well, okay, well, I hope I don't have to tell you so, but if you don't do anything, you're going to be abandoning your covenants and you might not be able to enforce it later. What happens? 5 years later, new board calls me, 10 RVs in the community. And I'm like, well, what do you want me to do now? And then I show them the emails and all the communications with the prior board. And I'm like, well, I can try to go to court on this person, but now you basically pretty much abandoned that covenant. I don't know if I'm going to be able to succeed. Now you might be spending this. So don't abandon your covenants. Enforce them. And if there's something you don't like, by the way, like I have a case going on right now. I had a meeting on Wednesday where they don't like the old fence provisions. And people are putting up fences that are not in compliance with the covenants, but the board actually is kind of okay with them. So instead of worrying about abandoning the covenants, what can they do to fix the problem? They can amend and then make the fence provisions the way they want to be so nobody's in violation of them. There's a lot of give and play in how this can all work out. Decisions. This is a big thing for your board. A lot of board members ask me, well, am I going to be liable for this? Or what's going to happen? Or how do I deal with this issue? So my answer to that in general is to, well, it's actually part of sub E as well. 5E is to be reasonable. But as long as you are reasonable, you are protected by what I listed in C. So maybe they're out of order. You have what's called the business judgment rule in Maryland and pretty much throughout the country, by the way. And it pretty much stands for the proposition that if a board of directors of a corporation, but I'm going to go broader than even communities, of a corporation, which community is, well, I should rephrase, all HOAs are incorporated, not all condos are. So technically, not all condos are corporations. But in corporate law, if a board makes a decision, a court shouldn't second guess that decision absent ill will, bad faith, or fraud, or something like that. And there are two cases in point on Maryland dealing directly with that exact issue. One is called Fox versus Black Hills, and the other one is Reiner versus something. I don't know, you can Google them. I didn't think I'd have to cite for non-lawyers. So, but there's two cases in Maryland that are great, and they stand for that proposition. So as long as you make any decision reasonably, the law supports that decision, and it's very hard for an owner to prevail over a board in any situation like that. They basically have to go to the court to prove that the board was doing something shisty or not being fair or selectively enforcing or something like I'm talking about. So as long as you're fair and reasonable and you listen to your experts and you do what you think is right, you are never going to be liable. You, individual board members, are indemnified for all of your actions and you should be protected.
Quick question.
Yes, sir.
In that scenario, if you have an expert that advises you to do this, and the board decides by majority rule to do that,
Well, then you're in trouble.
You're vulnerable.
Yeah, so what he's asking is, expert tells you to do A and you ignore it and do B. That is extremely dangerous and shows you that you were liable right there. What I would say is, if the person told you to do A and you don't agree, you better get a second opinion. And if the second opinion then tells you B is okay, then you can arguably rely upon that. But if you get a second opinion and they say A as well, you better go with A. And if you don't, you're in deep doo-doo. And by the way, if you don't follow the advice of your experts, you might lose your indemnification and insurance coverage, and you could potentially be personally liable. And I've seen that as well. But most of the times I've seen people personally liable, they usually stole money, to be frank, which is a whole nother category. Which, by the way, is why the fidelity bond law is out there. It's not really anything I'm talking about today, but there's fidelity bond law out there that requires all communities to have this insurance policy. So if Theresa would never do this, but if Theresa or Peggy were to steal your money, you're made whole and they're both going to jail. And I know people that I worked with just like them that are literally in jail now. So it happens. Yes, sir.
So on a different tangent, so you said HOAs are incorporated. Can they convert to not-for-profit?
No. Well, they're really not for profit, but if you're talking like 501c3 stuff and tax code stuff, which I don't really know too much about, no. They're not profit entities just designed to take care of the community. And if you look at your articles of incorporation that every HOA says, it pretty much says what I covered in sub A1. It's pretty much all you're supposed to do. And you're not really supposed to be making any profit or anything. You're just supposed to take care of the property.
And I'll talk about that later.
What?
I'll talk about that later.
Oh, and Teresa's talking about that later.
We have a question too from Zoom here. It says, does the HOA Act require new regulation to be recorded to be enforceable in court?
Good question. So let me answer that broadly. Let me start with condos and then I'll go to his answer next. So condominiums do not require rules and regs to be recorded. Your declaration and bylaws are all recorded in the land records. Rules and regs don't have to be recorded. By the way, you can record them if you so choose, but you don't have to. HOA's declaration is recorded in the land records, bylaws, and any and all rules and regulations or anything you want to enforce must be recorded pursuant to 11B112 of the HOA Act, I believe. Let me make sure. Yep, I was right. Must be recorded. And it says under C3, if a homeowners association fails to deposit any of the disclosures required above, which is all the rules and regs and everything else, then those disclosures which were not deposited shall be unenforceable until the time they are deposited. So it's very common that I get a new client on board and then I discover that there are no rules and regs recorded and they want me to enforce. And I'm like, all right, we got to fix that. And then usually what I write is a resolution. I attach those documents as an exhibit. And then I have the board execute it, ratify all the prior acts based on that, and then record it in the HOA depository. It's also not uncommon for developers to fail to record their initial bylaws in their HOA depository filing in the HOA depository as well. And I oftentimes have to fix that too. By the way, it's worth noting for the record, I do not do any developer work. I only do work from transition forward. So I live and breathe what you all live and breathe. I don't have any of that thought in my brain whatsoever. So that's a common problem that we fix a lot too. So does that answer that person's question?
Yes, he's good. Thank you.
Thank you. Good question, audience. Yes, ma'am, and I'll get back to you in a second,
Did you
sir.
mention before what the resource book is that you're looking at?
Oh, so I'm still a paper guy. This is the annotated code of Maryland. And this is part of it, actually. And this includes the condo and the HOA Act, which is what I live and breathe in. So I carry this with me everywhere. I'll get you and then I'll go back to you, sir, in the back. Yes, sir?
So when you say recorded, what does that mean?
So I don't actually go record it. I send it with an abstractor, but they take the piece of paper and they bring it to the courthouse and the courthouse stamps it and then they put it in a book. And then it's called, they use these fancy terms called liber and folio. Liber means book in Latin, I think, and folio means page. And each HOA has an HOA depository for their own community with the name on it. And everything in the HOA goes there. And then everything in land records, whether HOA or condo, goes in a liber or folio, and it comes back with a stamp on it. And you need to see that stamp, not just the stamp. Well, usually you just see the stamp saying like, Prince George's County Circuit Court, this date or whatever, or the land records, it's there. But then later it actually gets to a book and then you get it back with stamps on the top that show like liber and folio. That's how you know. And by the way, if you don't know that you have all the documents for your community and or if they're recorded, I oftentimes have clients order title from an abstractor and then I know anything and everything recorded among the land records. And I have a starting point to know that everything I opine on is proper. And it's also very important for resale packages, which is a whole nother topic. Because if you're not disclosing everything you need to disclose and there's a problem, that's going to harm your community later, because you might not be able to enforce if you didn't disclose something. Like, you don't disclose that your pets aren't allowed. Well, when somebody comes with a pet, well, that person's probably going to get to keep the pet if it wasn't in the disclosure statement or somewhere, or in a rule or reg or covenant. So again, everything's got to be recorded. And if it's not, there's no record notice of it to the world. That when it's recorded, it's called record notice in the law. And by the way, it's record notice even if you didn't know about it or didn't get it. Little tangent, anybody who buys at a foreclosure property is not bound to the resale disclosure statutes. So if Peggy buys a property in a community, she might not know all the covenants that are applicable to her, but she's still bound. Now, if Theresa bought through me, third-party transaction, and I sell, I'm supposed to get a resale package and give it to her. And ACM, if they were the manager, would produce this whole packet of stuff. So she's on full notice of everything that she's bound to before she buys in. So she should know if she's allowed to rent or have pets, or is this allowed, is that allowed, whatever it might be. Those critical issues. So does that answer that question? You got a question in the back?
Yeah, so you mentioned that HOAs are supposed to operate like a not-for-profit, where they're taking all revenue and reinvesting it into community. Is there a legal conundrum that one can run into if you're consistently making a profit, other than the fact that you pay additional taxes?
Well, first of all, I don't think most communities pay anything in taxes other than the personal property tax return, but I am not an accountant. I got to intermediate in College Park in Maryland in 1988, and I immediately shifted to finance because it was not for me. So my answer is to talk to the community's accountant, but let's see what Theresa has to say.
I forgot, I recognize your voice. Yes, you can be taxed at the corporate tax rate at 21%. Unless you are actually a 501c, which most HOAs and condos are not. There are not any other penalties, but you would be taxed on any what's called non-function income. So I'll talk about that later.
So that was not, my question was not whether you will be taxed, but are there any legal conundrums that the HOA can encounter for consistently making a profit? So
yes, if
the profit is going to be taxable.
Why are you making a profit? I don't understand. What are you doing? I mean, if a homeowner's pay $100,000 in assessment income and you spend 80, that doesn't mean 20 is a profit. That's 20 you're using and putting in reserves to fund projects later. Is there a real profit? I mean, are you doing a business entity? Like, is there, how are you making a profit?
I mean, if you are, as I said before, if you are a 501, you've requested, most communities don't, if you've requested tax exempt status under section 501c, then you can be subject to what's called unrelated business income tax. But you could lose your tax exempt status, but most communities don't file for that in the first place. You're just utilizing an election to subject the community to being tax exempt. Legal conundrum, there are nonprofits that make a profit. It's sort of a misnomer, but you would be subject to unrelated business income tax.
The only other topic I didn't cover under Roman numeral 5 was D, and that's the statute of limitations and laches. Laches is just an equitable term, which really means sort of the same thing, but I don't want to get you lost on that. Big picture, like I talked about abandoning with the RB case, like they basically lose the right to potentially enforce the RB prohibition, but the individual case that started it needed to have an action filed in the court within 3 years of when they knew or should have known of the violation. So I say knew or should have known. Obviously RB, but sometimes there are other things that come up when you had what we call inquiry notice, and you can't just hide your head in the sand. You need to act. And I don't mean sending letters. I don't mean fining. I'm talking court. So if Peggy puts up a fence without permission and the community doesn't allow fences today, you better file something by April 30th, 2026 or 25, sorry. And you better count the 365 days out, because it might not be exactly the same date, if you know what I mean, in the month. So don't wait too long. For collections, by the way, you can lean 2 years back under the Contract Lien Act for your collection cases. So oftentimes HOAs have a more difficult issue with collections because the fee's smaller. So some of the HOAs may choose to lien every other year to save money on the attorneys. So you can do that every 2 years, but for lawsuits for collections or covenant enforcements or anything, generally 3 years. So don't wait. And by the way, don't wait either. In general, that's the be all, end date. But if you get something filed earlier, you can have judges that could be more empathetic to the owner, thinking you didn't really act timely and they were harmed by you not acting timely. So you never know.
Greg, we have another question here. Can record stamps be digital? Some documents marked make it unreadable.
Can you say that again?
It says, can record stamps be digital?
Can record stamps be digital? I don't even know what that means.
Okay, well, we can come
I'm
back.
not a techie, but they have a blue stamp and it comes back with a library folio.
Or you submit it online. These days you can submit documents in some counties. I guess.
You can submit them, but I still think
Metadata in the file.
I'm not a techie. I don't know how to answer that. Sorry. And I don't record myself. I send them to an abstractor and it's cheaper for our clients. They give it back to me. I don't know how that works. I'm sorry.
Okay.
Sorry. I usually know the answers.
Research.
That's the end of Roman numeral 5. Anything else on the whole first topic in part 1? And it looks like I got like 30, 40 minutes left still, so let me keep cruising. All right, meetings. Let's talk about meetings. Here's a great example. And these exhibits are in your handout. So I gave you some statutes. So let's keep it simple before you get lost looking at the statutes. Don't just hold on. So meetings. You have open meetings, closed meetings. For HOAs, for condos, I included 11109 of the Condo Act. You don't really need to look at it because it just talks about the open meetings. It's got a lot of other law in there, by the way. If you're a new board member, I would read 11109. It's worth a read. 11109.1 of the Condo Act and 11B111 of the HOA Act are pretty much identical. And they state the only reasons you're allowed to now close a meeting. And I'll read from 11. All 3 of these are in the handout behind the outline. Oh, actually, it came to you as a packet that said statutes, I think. So you can close a meeting for discussions of matters pertaining to employees and personnel. Second topic, protection of the privacy or reputation of individuals and matters not relating to the Council of Unit Owners business. 3 and 4, by the way, are the ones that I am personally involved in on a pretty regular basis with all my clients, is consultation with legal counsel on legal matters. And 4, consultation with staff personnel, consultants, attorneys, board members, or other persons in connection with pending or potential litigation or other legal matters. 5, investigative proceedings concerning possible or criminal misconduct. 6, this one gets abused sometimes, consideration of the terms or conditions of a business transaction in the negotiation stage if the disclosure could adversely affect the economic interest of the Council of Unit Owners. So that's really, it's hard to really fall in that category in my mind, because as long as nobody's talking to the various vendors, you're going to get 3 bids and you should be talking about the topic in front of the owners and getting feedback from the owners and having it all in the open. But there are certain times when 6 can come into play. 7, complying with specific constitutional, statutory, or judicially imposed requirements, protecting particular proceedings or matters from public disclosure. And 8 is an interesting one because it's discussion of owners' individual accounts. And depending upon the severity of the delinquency in your community, I have a lot of boards discuss this in closed sessions and a lot discuss it in open. You don't have to discuss these things in closed, although 3 and 4 with me, the lawyer stuff, most of the time should be closed. But if you're in a community with a lot of delinquents, it might be good to talk about it out in the open and not hide anything, because in a sense, you're giving them the scarlet letter in public. And you're trying to put the pressure on the owners to realize, the good owners, to make the bad ones arguably feel bad, to get the bad ones to pay. Because at the end of the day, if the bad ones don't pay, it's all the good paying owners are going to have to pay more, because the manager is going to be telling you that to increase the assessment to cover the shortage and the attorney's fees you have to waste on me or somebody else chasing them. So a lot of different things with collections.
The first one you mentioned, employees and personnel. Personnel is rather ambiguous. I've done a lot of research. When it comes to a board wanting to talk about a committee member or a board member, is that personnel?
What do you mean? If board members doing something wrong?
They just want to talk about a member of a committee or a member of the board.
But I gotta know more to answer that question. What's the problem?
We're assuming it doesn't.
Yeah, there's some violation.
With them personally?
I just don't like what they do.
Yeah, they don't care for the way he or she.
Oh, so you're talking about a minority director who's a jerk who creates problems everywhere, right? Well, I'm dealing with that right now, and I was responding to emails last night and this morning before this class on that exact issue. So that's under sub 3 and 4. I'd be speaking to your counsel and closing the meeting. There are certain points where once you've strategized, which is what I'm doing, and I actually told him I'd be talking about this jerk today, which I'll get to maybe a little bit. You try to work within to get them to comply and play with everybody properly and understand a majority of a forum makes a decision. But if that minority won't listen to that decision and does things rogue on their own, which is what I deal with pretty regularly and have a fresh one right now, then we start talking to them about coming back into conformity or resigning, or next I'm going to tell the whole world, not the whole world, the whole community about you and seek your removal. And sometimes it's very unfortunate and you got to lay out all these bad things. I'll go on a little tangent for you on that exact topic. And this is what directly relates to that issue. So what I told Theresa on the way in, I brought my best set of HOA and condo docs when I amend, because almost everything I talk about is in here in a community's documents when I amend them, all the cutting edge laws and things. So what I put into some bylaws a few years ago, dealing with another jerk like this, is this, and this deals with the exact issue you're talking about, and it's such a great provision. Tell me what you think of this, because I bet you this is exactly what you're talking about. I call this the duty of loyalty, which, by the way, is generally the law, but I put this in covenant so I can use this in my letters when I'm latching onto those difficult board members. If you can bear with me, I'll read this one paragraph. All directors are encouraged to share their views and opinions during board meetings and to participate in spirited but civil debate over matters affecting the condominium. By the way, if it's an HOA, I switch the terms. No director is required personally to endorse a decision of the board from which that director has dissented or intends to dissent, but all directors must speak with one voice as directors once a decision of the board is made, even if the director was in the minority of directors whose opinions were not adopted as the official position of the board. Directors may discuss their opinions freely and openly amongst themselves, subject to any applicable constraints requiring confidentiality, provided, however, that such discourse does not constitute a meeting of the board, tying this all together, and held in violation of the applicable open meeting laws. By the acceptance of a position of the board, each director member thereof agrees to work within the condominium's processes and systems to advance its position. Here's where you go, but not to work individually or in collusion with others to subvert the legitimate work of the board or the condominium. That's what you're talking about, right?
No.
Uh-oh. That's part of it?
That whole discussion, is it in a closed meeting or an open one?
Well, in the beginning stages, I would be talking to them about it in closed, but if the board member then doesn't work with you, I'd start bringing it out to the open, to the owner. Remember the powers I talked about initially? What's one of the powers the owners have? What's the big one that's right relevant to your issue? I'm being Socratic here. Remove. The owners have the right to remove that board member. And that's what you're going to have to do with that jerk. And I've dealt with that a lot.
Jerk is subjective, there's due process.
I'm generalizing. I can use better words, but I'm on video.
You were talking about scarlet letter and confidentiality. So can you disclose the identity of the delinquent owner at an open meeting?
Yes, because everybody has the right to know what's going on in their own community. Furthermore, under 11-116 of the Condo Act and 11-B-112 of the HOA Act, anybody has the right to inspect the books and records of the community, which would include the delinquency reports that Joanne, superstar collections person in the back of the audience.
Where did that come from?
What?
That whole direction that you're not to disclose delinquency, that's been around.
Yes.
Oh, so they're asking why you arguably shouldn't disclose who's delinquent. Well, obviously, if somebody's upset that it's out there, they can sue. And then if you get sued, you're in a lawsuit defending yourself. But so if you want to be super conservative, don't do it. If you want to be conservative and you have a litigious society, a litigious community, you can do it in closed session and avoid these issues. But sometimes it's so bad and collections is so horrible that it's at the core of the issue for the community survival. I mean, look, I don't know if any of you know, but you can Google this. There's a community called Lynn Hill Community. It was in Prince George's County. I was involved. They didn't listen to me, and now they are no more. They went in and out of 4 bankruptcies. I was involved. It's the only community I'm aware of in the state that is no more. We got a court order terminating them in the circuit court, and then we went to the bankruptcy court and they sold the condo to a developer who then converted it back to a landlord-tenant situation. New carpet, new paint, now it's being rented. Gone, because there were 50% of the people in the community in my office. It was horrible. And they didn't have enough money, and then they didn't have the money we're going to shift to Surfside a little bit now in the disaster in Florida, which is in my outline at the end. But if you don't have the money to keep the upkeep in your community and you can't fix it, and the elevators don't work and the roof is leaking, the county's going to start citing you. And if you don't have the money to fix it, you're being shut down. And then you have no ability. You either need to get a loan, you need to increase assessments, you need a special assess. But when you continue to have people that can't afford to live there and doesn't have the money to pay for the infrastructure, you're out. And it's not going to work. So, big picture, there is no law that says, there is no case that says you can't publish delinquents, if that's what you're asking. I'm not aware of any case on this. I had to research because I had some clients who wanted to do it. But despite that, I am aware of some people suing over it, and lawsuits can be headaches. I believe in the right situation with guidance from counsel, you can do it properly and you will win, and it's defensible. Do I necessarily think all communities should do it? No. You got to be very careful. And if you look at my collections outline, which we're not at yet, we'll get there. Number 6B is publishing delinquents on my chart. We're not there. But yeah.
And please talk about the detriment of holding assessments, because we see that a lot.
Holding assessments?
Just not wanting to increase and not funding.
Oh, well, that gets to what I'm getting.
Yeah, I know you're.
I'm going to get to that. So she's asking, all right, I'll go on one tangent.
So detrimental.
There are many board members that I've seen in my career, and any manager knows this, who pride themselves on being elected because they're not going to raise the assessments. That is bad. I understand about the pocketbook, and I never want to pay, but inflation is what it is. And the Surfside disaster occurred partially because of that. And many of my clients have the same problem, and they can't pay their bills. They can't pay their attorneys. They can't pay their engineers. They don't enforce against the recreational vehicle because they're all afraid of spending the money. But what is the community about? And you need to have the money to do all of those things. And if you don't, you're not budgeting properly, period. So does that answer that question?
I have 2 more questions.
Where did that come from?
Thank you, that's a great answer. So we have 2 questions. Another general question for Craig. What notice, if any, has to be given to owners when there is a special board meeting?
So special board meetings sometimes only have short notices, but I don't really like that. I always use the minimum. In the Condo Act 11109, the statute I showed you is 10 to 90 days notice for any open board meeting. So I like at least 10 for condos. Most HOAs say 15 days. But there are certain situations where you have to have an emergency meeting, by the way, and then we will do what we can and whatever is reasonable. I don't think the HOA Act has a date. Hold on, 11B112. I don't think it specifically has a statutory time like the Condo Act, so I follow the bylaws. And it's usually 15 for HOAs. I don't know why.
Usually that is fine.
So here, 11B111 is the meeting statute for HOAs, and it doesn't have a number like the Condo Act. It says reasonable. Back to your first question. So, is a day reasonable? No. Is 15? Yes. Is something in between? It depends on the circumstances. What if you had some disaster, like a snowstorm or a hurricane or a tree fell or something crazy and you need to go right away? Well, I would do everything you reasonably could to make it so that everybody had the chance to be there, and no judge down the road could say it wasn't fair. Because what happens is, you can get away with a lot of things here and there, but the question is, who's going to challenge it, and then were you right or wrong? And is it going to end up in a judge's hands? Or we have a lot of attorney general complaints. People go to the attorney general on a regular basis because they're free. So if they don't have the money to go to the attorney, all you got to do is write the AG, and then I or some other attorney are spending thousands of your dollars responding to them because of those issues.
Another one going back to collections is if a homeowner files bankruptcy and the house is owned by the bank and is sold by the bank, is the bank responsible for paying the assessment arrears? If so, if they didn't, how does the HOA get the money from the bank?
Totally off topic, but I'll try to hit that, and we'll get to collections in a little bit. But whoever's on title for the community owes the money. So I'm gonna keep picking on Peggy. Peggy owns the property through March 1st. She's liable. Bank forecloses, and let's just presume the bank buys it back March 2nd. And then they don't take title, by the way, till the court ratifies it 9 months later. They pay when they take title, it relates back to the date of sale, and they have to pay from that point forward. Most of the time, the banks don't pay during the interim period. They're just not set up that way. So we just lien the property, and then they pay at settlement when they sell to a third party. Does that answer that question? Hopefully we'll get a yes.
Yes.
Okay.
More questions? Good? Yes.
Quick question, back to open and closed meetings in general. Are you speaking only of board meetings? What about subcommittees and special forces doing different
Great
things?
question. So she's asking about committees and stuff. Both statutes include any and all committees. So a lot of people try to get away with that. The board members, so they don't know the statutes. Like, well, I'm just going to appoint this committee or that committee, and then they can go to somebody's house and talk about it. I'm like, no. That committee has to give notice to the whole community as well. And I don't care if we're talking nominating committee, election committee, landscape committee, holiday party committee, whatever it is, think big picture, due process, what you see on TV with the lawyer shows. Everybody has the right to know what's going on in their community. Everybody has the right to give their input subject to some control, because there are a lot of out of control people in these communities. And the board makes the decisions absent amendments in general and everything I talked about so far. How am I doing on time? I don't want to take away your two other presenters.
20 minutes to do collections or whatever you want to do from here.
Okay, thank you. Email voting. So this ties into open and closed meetings, but I included an article. So these statutes are in order of my outline. And John Chickardano, one of the great attorneys in my firm, wrote this great article on email voting and is it allowed? So this is a little gray area of the law. I'm just going to go on to just explain it for a little bit. So big picture, you should not be voting on email. Anything that doesn't fall in that closed meeting topic, you should not be voting on email. I don't care about how we all use email these days. It is absolutely inappropriate. And if you do it and get caught, that whole decision could be stricken. So we're talking about hiring a landscape company, and that's really something you should generally discuss at an open meeting. You don't want to make that decision in between meetings unless there's some emergency, and then we can talk about special meetings or whatever. You should not do that. But let's just say I need a quick decision as your attorney on a piece of litigation, and I can't get the board to meet, and they all want to talk about it and figure out what they want to do and vote. I'm okay if they all communicate on that closed meeting topic on email, and they all say, okay, we're going to decide this through email, and then they vote, and a majority of the board decides, you know, Craig's going to do that or this or whatever the issue is. To me, even though there's no law on this, that's okay. Why? Why is it okay? Because you didn't deprive any owner of any due process, because they don't have to be there anyway. So as long as the board agreed to do it via email, I'm okay with it. And by the way, I ran this concept by the Attorney General, who I've had many cases with and a pretty good relationship with, and they generally agreed with that. Well, they generally supported that concept and interpretation. That is all explained in this newsletter, so a good bedtime reading for you later. Questions? Because I know
that doesn't limit Zoom voting, because the public still has access to observing those votes, right?
So I'm talking about just closed meeting topics that the public would not see. On open meetings, yes, everybody can see everything on a Zoom meeting, and based on the new virtual meeting law, which I guess you're talking about. Yes, but that's only open meeting issues, normal meetings, not closed meetings that you would know nothing about as an owner. So you have a problem with your community, and and I'm your attorney, and you, me, Theresa, and the rest of the board want to meet. No one's going to know about that. Unless you have a rogue board member like the jerk I'm dealing with right now, who's telling everybody everything when they shouldn't. And we're going to have to deal with him. Those are big problems.
What about a procedure where email votes are ratified in open meeting?
Well, I don't like that, because then you didn't have the input from the owners before you made the decision, and you deprived them of their right to give them their feedback to the board. So let's just take management as an example. So you want to shift, maybe it's a bad topic. Accountant, you want to shift your, you want to shift your accountant, and you know, somebody in the audience knows the accountant and believes he's a really good accountant, you shouldn't shift, and others feel the other way, or whatever the issue is. Everybody's got the right to talk about it. The board has to listen to these people, and then they can make an informed decision. The board, in my opinion, did not make an informed, maybe they still made an informed decision, but it wasn't fair with due process to the owners. So I don't think, I mean, if I'm the attorney on the inside talking to the board in a closed meeting, I'm going to tell them if they already did it, but that's the best you can do is to ratify it at the next open meeting. But that's what I'd be telling them in closed doors, because that was wrong. I wouldn't be telling the open meeting audience that the board screwed up and did it improperly.
Can you replace B, email voting, with email decision-making? Is it any different than what you just went through?
Well, no, an email vote, email decision. I think of that as the same thing. Yeah. Budgets. Meetings. Oh, working sessions. I'm sorry. Last thing. C. I'm going too fast. So now we're getting, so we just talked about open and closed meeting laws. Then I went to this email voting, which is a little grayer. Now I'm going to go even grayer. And this is dangerous territory. I'm just being honest. So there are these things called, this is before the law. Everybody did this, but now lesser people do it because it's more dangerous. So you can have working sessions. I believe you can have them. There is no case on this. And if you're challenged, I still believe you would win, but you might have to spend money on attorneys fighting it. So you have to figure out what risks you want to take. And if you're in a more litigious community, like I find in general these days, more of the wealthier and affluent communities I manage have more litigation than the poor communities. And people are willing to fight over anything. It's unbelievable. But let's just say you have some big capital project, like rebuilding the pool. And you got, it's like $400,000 project, and you have 3 bids, and it takes you like 2 hours to analyze each one for 6 hours. Does it make sense to sit in front of all the owners for 6 hours talking about this? I say no way. So what do? I can say, if the board call me and they want to find out little tricks and what you could try to do to get away with things a little bit and play with the law, I would say, look, go have your working session, go meet in somebody's house and talk about all these things for 6 hours, and condense it to a summary of an hour that you can present to the ownership at an open meeting. And then you tell the ownership everything you did in that discussion. And by the way, no decisions were made in that meeting, nothing. You can, in a sense, narrow down that you believe these are the 2 best of the 6, but no decision. And then when you present to the owner, say we talked about person A, company A, B, C, D, E, F, whatever it is, and then what do you all think? Let them talk, board makes decision. I think I would win that case, and no attorney general or court would tell me my client's wrong. Now, could somebody sue saying you had a meeting outside? Well, it was a physical meeting, but I argue it's not a real meeting because no decisions were made. So worth knowing, board members, careful, and this depends upon what you're talking about, how much risk you want to take. I don't know if any managers have any feedback on that or experiences.
We know it happens often, right? That we have to make these planning session meetings, and you're right, working sessions are a thing. Just never make a decision, please. Save that for your actual board meeting, but we know everyone does it. Thank you for clarifying that. It gets asked a lot.
Okay.
We have another question. All right, please ask Craig to comment on corporations law article provision that allows board members to unanimously agree in writing between meetings.
That's a great question. Who asked that? It's one of my clients.
He used to be an attorney.
Oh, really? Oh, cool. Is he not a community association attorney?
No.
So whoever that is, he asked, what about the corporate law that allows, that requires a unanimous decision if you do it the way I'm talking about? So to that person, great question. And we analyzed that law and spoke to the Attorney General about that, and that's addressed in my article. So our position is that a community association and their documents and their bylaws are different, and clarify that a majority of a quorum can make a decision. And so long as the 5 of them, let's pretend the board is 5, agree to discuss it via closed meeting, I think there's a distinction between that and the regular corporate code. But I believe that attorney is correct regarding all other corporations. But in general, when you look at the body of law, that corporate code is broad, and the HOA and Condo Act is more succinct and more narrow. And I believe the more narrow law would control in that situation. And that's directly addressed in the letter, that exact statute he's talking about.
Perfect.
So read the article. It's Yeah, and have him, he can email me if you have further questions as a lawyer. I'd be happy to hear your thoughts. I always like cutting edge issues. All right, budgets, huge issue, ties into some new law. I'm sort of jumping around a little because I'm really excited about what I just found out yesterday. So for condos, 11109.2 is the budget statute, and for HOAs, 11B 112.2 is the statute. Everybody should have this watching or in the audience. And basically, you have to work with your management company to budget, and you need to, in your budget have income, administration, maintenance expense, utilities, general expenses, capital items, and I skipped reserves for a reason, because reserves is a huge issue. Again, think Surfside, think what I talked about with board members, not increasing assessments, not having the money to fix things they need when the boiler goes out or the roof leaks or whatever. You have to budget, and many communities have not budgeted property, kept their assessments artificially low, and now they can't pay their bills and they're suffering. So what happened? The Lynn Hill story I told you about. Prince George's County ended up eating a lot of money because of what happened, because they had to condemn the property. And because of that, everybody goes to the lobbyist, and they passed a law 2 years ago that said any community in Prince George's County has to get a reserve study, and then whatever money you are deficient in your reserve account versus the report, you must go assess everybody the money to replenish it. So if your reserve report says, I'll give you a real example, I have one property in Prince George's County that needed $2.3 million in reserves per their reserve report. And do you know what they had? Zero. So under that law, they had to specially assess their owners and divvy up $2.3 million between 300 homeowners. The year later, 2021, they passed the same law in Montgomery County. And by the way, each time the legislature tried to get it applicable to the whole state, but there was fighting on that. So PG really needed it. Then they added it to Montgomery County. And then what, by the way, legislative session is generally January to April 15th. What happened last summer? Surfside disaster. Everybody watched that, right? I have family members who knew family who died. Horrible situation. Why did it happen? Because if you read about it, they needed so many repairs that they had to do a massive special assessment, 80 to 120,000 per unit for the infrastructure. And they're all sitting there like, oh my God, we can't do this. And they themselves couldn't afford it. And horrible situation, which is why, again, a lot of board members vote not to increase assessments. That happens all the time, but just not to the deadly effect that happened at Surfside. So I knew, by the way, I belong to this group of crazy lawyers like me across the country. We have this group chat, and we all talk about these crazy things or crazy cases I have. I'll write them. They give me advice. We all help each other. It's a tight-knit little community. So we're all going back and forth about this disaster, and we're all talking about, within a month of it happening, that almost every single state in the country is going to have a new law dealing with this exact issue. And in Maryland, we were predicting they were just going to expand the law that was applicable to PG and Montgomery to the rest of the state. So I skimmed all the new laws yesterday, and here they all are. Oops, sorry about that. And I was correct, as predicted. And the new law is now going to be applicable to every community in the state, although they did make it a little easier on some of you. So back then, you had to do it immediately within a year. And that was one of the problems, that people are all struggling to pay and they didn't have the money. So how are we supposed to do this? So they made it a little softer. Big picture, they made it applicable to all communities, and they're giving you 3 years if it's your initial study to now replenish it. So under my scenario, if they didn't have a reserve report before and they got one, and so they needed 2.3 million, they have 3 years to get the 2.3 million. But if you already had one, you still got to follow that. They just tweaked it a little for the new ones. So big picture, the reason I'm talking about this in the budget section is because now you're not just budgeting for reserves based on what your manager says, and you don't have the ability to say, no, we really don't want to put this away or not that much away. You're going to have to get a real reserve report. You're going to have to look at it. You're going to have to analyze what the difference is, what you have in the bank and that, and you're going to need to plug that in there and now work with your managers and your accounting people, which is not me, and evaluate how you're going to replenish that sum, and whether you have 1 year or 3, all depends upon what you already have in place. I'm also personally a little worried because I think some of the shiesty people out there are going to start playing with reserve studies in a way to try to skirt the law. So let's just pretend you have a shiesty board in my $2.3 million community. They're going to pay somebody under the table to write a report for saying they only need 500 grand in reserves. And then they're only going to collect 500, and then they're going to be short. I'm just predicting some of the things that I see that might happen down the road. I have no idea if I'm right, but I've seen so much in this industry over the past 30 years that anytime a new law comes out, I'm always thinking, well, how is this going to play and what's going to happen and who's going to try this or that? But don't do any of these things I'm talking about. The law is the law, and this is good. This means you're going to have a healthy bank account. It's like any of you saving with your 401k. That's what this is. It's a 401k for your community, and it needs to be done. And now I'm not going to let any boards get away with the stupidity of, well, we don't want to raise our fees. Well, I'm going to say you have to. And managers out there, use this as ammo to get your board to increase the fees. And then I'm going to go one step further to hit the collections issue. I don't, one second, let me get this part out. I can't have a heart sometimes in my job. I mean, I am a really soft guy, but when I'm sitting there listening to the community with the 55 plus person or some financially strapped person, they say, well, I can't afford that. I say, well, get out. You all need to get people in your community that can afford to live there. And if they can't, get them out. And if they won't get out voluntarily, foreclose on them. This is what happened in Lynn Hill. You must get rid of the people that cannot afford to live there. And what I see over the next 10 years is a massive transition of ownership in condos and HOAs because of this statute.
What is this new law?
It is in House Bill 107 is the new reserve law, and it will end up being in, these will not be effective till October 1st. For the Condo Act, it will be in 11109.2 and 11109.4 of the Condo Act. And for HOAs, it will be in 11B112.2 and 11B112.3. And any of my clients out there, you'll see this in a newsletter. If any of you are not my client and you want to get the newsletter, I guess give ACM your email. I'm happy to add you to my email list for articles and stuff.
Yes, is
That's
there a time limit on a reserve study, how long it lasts for?
Yeah, I mean, I can't get into all the minutia, but yeah, you have to get a new one every 5 years under the new statute. No, the whole state now. Everyone, every single person listening, if you live in Maryland, you're gonna have to comply with this. I believe all the new laws are gonna be effective October 1st.
Right, there's more than one way to calculate the funding for reserve study.
I know, that's another little trick. Great question. So that's where I got a limited time here. So she raises a great point. She's asking about there's different ways to calculate it. The statute doesn't actually get into those different ways. And when you see these reserve reports, there's a lot of time, I don't want to get lost. Sometimes there's 3 different ways to figure it out, cash flow or this way or that way. I want the clients to do it straightforward and proper, real cash, real money, what you need. I again see reserve people playing with what you're talking about to try to skirt the issue. I mean, I'll already tell you, I had one client in PG before play with this, and they had an issue with their common area, and they put a footnote in the reserve report and left it out because it was a big expensive item that they're trying to deal with on purpose. So I know that's wrong. I can't get all my clients to listen, by the way, but that's an example. They were already there because that law was applicable 2 years ago for them. And they're playing games with the reserve report because they don't want. It's a question of whether they should maintain this big giant retaining wall. It's a massive expense. So if you put it in the report, they need to assess huge amounts. If you don't, they don't. So they're playing games already, which is where I'm coming from. Not good in my mind, but I cover my butt and give advice to the managers, ACM, cover your butt. If they don't listen, it's going to be on them. By the way, back to your individual liability. If you don't listen and don't follow law, you might lose your indemnification and you might be liable, and the owners could have claims against you personally. Maybe. We'll see what happens.
But the law doesn't state any specific method of calculating this.
I don't think so.
But there are standard methods that the engineers use, like cash and component method.
Absolutely.
Yeah.
There's a big difference in the two.
It is. And both are acceptable.
So let me hit the other 2 new laws that are really important, and then because collections I can only just touch on, and then I gave you a big outline on collections, which I'll get to in a minute. A lot of bedtime reading. So let me hit the 2 other ones. This one, virtual meetings one is funny. So for those of you know, virtual meetings was really cool last year. New statute came out. But what happened? I don't know if any of you experienced it. a lot of board members and managers muted a lot of people and didn't let them talk during the Zoom meetings. So those people all went to the legislature. So that the same statute that was amended on virtual meetings last year got amended a little more to basically say, you basically can't mute everybody and you got to make sure they all have an opportunity to talk. It's specifically on point for that issue. The last one is my favorite. I've been waiting 20+ years for this. I'm so ecstatic, and this is the one I wrote you the email about, Theresa. So most of you know about the Condo Act I was just talking about and the ability to fine by statute. There has been nothing in the HOA on that. There has been no right to recover attorney's fees in the HOA. So if you have a problem in a community, you have no ability to fine. And if you take them to court because of the fence issue and you don't have an attorney's fees provision, you're going to spend money on me, you're going to win. The fence is going to go down, but you sort of lost on the financial side. In Maryland and almost the country anywhere, you can't get attorney's fees unless there's a statute or contract on point. So HOA Act just adopted 11-113 of the Condo Act, and now all HOAs are going to have the right to fine by statute, and all HOAs will have the right to recover attorney's fees as well.
Effective
October 1st. Now, I will tell you, there is a flaw that I don't love. So sometimes you have rules and regs in communities in the broad easement section in your declaration. It says oftentimes you have the power to make rules and regs over the common areas. Well, now with this statute, that means you could fine for those rules. But in some communities, it doesn't say that you have the right to make rules and regs over the lots. And that's a huge problem. It should, in newer documents, it'll say rules and regs over the common area, the lots, the homes, the behavior of the people. Old 70s and 80s documents often just say rules and regs over the common area, like your pool, your tot lots, your tennis court, but not the homes themselves. So unless you have a covenant or a rule right on point regarding the lots, you might not be able to fine for the lot violations.
Will they have to amend their bylaws if their
Yes.
bylaws don't provide for fines?
No, they will not.
But that's
It's going to be the same statute as the Condo Act. It says unless the documents provide otherwise. So if they don't provide, then you'll have the right to fine. If they amended, like if I amended a lot of HOAs to give them the right to fine already, it'll be almost
You
the
can
same.
say 15 more minutes if you want. If you're-
I got one more topic.
And can you talk a little bit about restricting access to covenants? There was a law a couple of years ago.
Yeah, I talked about it in the beginning, but I'll re-hit it.
Yeah,
So anyways, those are the three new laws that I really wanted to touch on. There's more and they'll be in our newsletters, but those are the ones that I thought were really interesting. The rest are that, I'll let you know about them. Yes.
So you cannot can you limit the time they can speak?
The time for what?
The time, can you limit the amount of minutes they are allowed to speak?
Oh, you're back to the open meeting issue and on the muting. Yeah, I mean, in open meeting, virtual meetings, whatever it is, you can set up rules and regs about the time that people can speak. And obviously if they dominate, control them and restrict, you got to be reasonable. I know you don't like that word from your questions, but yeah, if I have crazy people in the audience, we might start off by limiting people to 2 minutes and, but if somebody's speaks well and they have good points, I don't really like to cut them off if they're adding to the discussion, but if they're jerks and they're going on tangents, just shut them down.
You mentioned that-
No, I'm pointing both of you. I don't know who wants to go
you
first.
mentioned that HOAs can recover attorney fees. Can condominium associations recover? attorney
That's
fees?
already been law since I started back in '93. Yeah, it's in 11-113. Basically, the new statute, it mirrors the Condo Act. So it's exactly what we wanted. So just to let you know, anybody who really knows exactly what I'm saying, 11-111 is the rulemaking statute for condos. My first response in reading all the new law was, now I want 11-111 in the HOA Act, and it closes my gap on the lot issue I just mentioned. So that's what I'm going to be writing the Legislative Action Committee, thanking them for all their work and seeing if we can shoot for that next year. By the way, that statute is, it's going to be in the HOA Act 11B 111.10. It's new. I forgot. It also alters, 11-113 a little bit for condos. Any of you know, this is important for ACM managers, you need to hold a hearing to fine under the Condo Act. They shifted it with the change here. They now made it so that you write the owner a violation and they have the right to request a hearing, but you don't need to hold the hearing with them if they don't ask for it. I'm still going to be suggesting to all my clients, to get all the witnesses together and to hold the hearing. Why? Because of the decision I talked about earlier, and then you're protected by the business judgment rule. So even though the person put up a fence without permission, I want the decision on the fence without the permission on the record, so that if I have to go get an injunction for her about the fence, the judge hears that and then doesn't want to second guess that decision and supports what the board did. Make sense?
Defect construction, it's not recoverable, attorney fees?
Attorney's fees, well, I mean, attorney's fees are, here. The prevailing party in any proceeding under this subsection is entitled to an award of counsel fees as determined by the court. And this is in the HOA and Condo Act. But without that, you wouldn't even have the right to ask for it. Now, I don't want to get too lost. What you can get or not depends upon the judge you land in front of, as Joanne knows very well back there in the right corner. More so in collection cases and covenant enforcement cases. When you're dealing with collections, sometimes the judges are more empathetic to the owners when they really shouldn't be, because in reality, they're not harming me or Joanne. They're harming the good paying owners. And in my position, the bad paying owner that caused the fees to be incurred should pay them. When you're in the circuit court dealing with the fence violations or the jerk I talked about, or any of the other numerous things that are out there, which is anything 30,000 or over, anything equitable, the judges are not as empathetic to those issues. So I'm not worried. And this 11-113 thing and the fining for HOAs is all stuff that the judges are not empathetic to. You put up a fence without permission, you don't pick up your dog poop, whatever it is, we almost always win those cases and the owners get slammed if they really fight. And because they're wrong. So this is like huge for me living and breathing in this world. Like I don't know if I've ever been as excited about a statute. This is going to help so many of my clients. I sort of bounced around. I went from C to E. Last topic is collections. So what's the time?
10 minutes-ish.
Okay. So what I have here is a little packet. Yeah, I'm sorry, green, late in the green.
So going back to regard to the HOA and being able to collect lawyers' fees, can we go back in retrospect?
No, it says it only affects disputes from October 1st, 2022 forward. I will also tell you, I'm already strategizing. I have some cases with clients that don't have attorney supervision or fining, and depending upon the violation, I'm going to have them stall now till October. And then I'm going to sue in October. And that way not only are they wasting money, I say wasting, we're good attorneys, but I hate spending money on attorneys too. So if they're spending money on us, I like to win for them and get it back, or at least have the shot at getting it back. So I'm going to stall and use this statute and file after October. I might even hold some of the fining till then, because I don't even want a smart attorney on the other side to argue, well, the violation really started before, or you held this hearing and then you just waited. Like, I'm trying to think of everything that could possibly be argued by a good attorney.
So what's your success rate against people who are in the military and they've got Jack?
What my success rate on what?
With regard to going up against military people who have the Jack. Jack is the.
Oh, military people. Well, I mean, there's law on that. God, I don't do much collections myself anymore. The military affidavit act, I forgot what it is. When certain people are in the military, you're not allowed to do certain things. I'm far removed from that now. Joanne, can you help at all with that topic? No. You got to talk to your collections attorney, but there's certain things you can't do when they're overseas.
Come on June 7th, we're having a collection seminar.
I think somebody else in my firm is helping with that.
Sean,
Yeah, okay. So come to that. I do not have that at all in my outline. That's an interesting, it's called the Soldiers and Sailors Military Relief Act. And again, whatever the law is, you have to follow it. So if they're protected, I can't go after them. But that just, you can't foreclose on them. I can still lien and protect the community. So there are certain things you can and can't do when they're gone. Okay. And I don't remember, I mean, I used to go to court literally 3 and 4 days a week with Joanne in my heyday. I just don't do that anymore. So I got other people that do all that. But anyways, I still know the nuts and bolts of everything, and I still live and breathe it. So this packet is actually something I give out to a lot of my new boards and my clients. So you basically have the same thing I give my clients. And you'll see it's just a little cover letter for me. And what I compiled was a bunch of articles that is really fun. If you like this stuff, bedtime reading, everybody. And I have an article in there. I can't go through everything, but there's leaning. There's an article on leaning. I'm skipping the first 2 pages. It explains the whole leaning process. And then I have some collections outline stuff. Then I have the filing of a lawsuit. It teaches you everything about lawsuits. Then I have an article on post-judgment collections, which includes, going after their wages, their bank account, taking their house. Then I got a whole article on foreclosures and writs of execution. Let's see what else I put in here. And then I have in here the issue that Theresa just asked me to talk about, suspension of privileges. So let me hit that, and then I'll go back to the outline in here real quick, and then we'll run through that, and then I'm done. So what Theresa asked me about is the suspension of privileges. For 25 years of my career, all of my clients suspended the right to use pools. They took away parking rights, didn't let people use the tot lots if you were delinquent. We wrote out policies. And then somebody, and actually, is Alan still working here? So a guy who manages the properties here, community, did this exact thing like all of our clients did, and they got sued by this law firm that sues people in our industry for fun, and argued that the community's documents didn't give you the right to take away anything for non-payment. You have the right to lien, you have the right to sue, you got the right to foreclose, but you can't take away these things. And we, of course, argued that's ridiculous. I mean, why should they get the benefit of everything if they don't pay? I mean, it's absolutely an absurdity. But nonetheless, they won, and the court said, you have to have the specific power in your declaration. It was a condo case. And that's the part I talked about. I got involved after the trial, because what happens in a lot of these cases, insurance defense defends the case, and there are attorneys that are not in our industry. They don't live and breathe it. They don't really know it. So a different management company was involved in that case, and they worked with me like ACM, and they hauled me in to try to help at the appellate level. And I tried to do the best I could with the record, but they still lost. So went to a higher court, and they ruled against the community. Then what happened? The legislature adopted a new statute directly dealing with this. 11103 of the Condo Act. Actually, they added a part to 11103. 11103 is the same statute where we started, which talks about a community and the creation of the declaration for a condo and what you have to put in the declaration, which is describing the common elements, units, limited common elements. The same statute is where they put this. And they said, condos have the right to amend the declaration to give you the right to suspend those privileges for non-payment, so long as you give them the right to a hearing and or to clear the debt. So if you go through those procedures now, you can take away the right to use the pool, parking, whatever it is. So you have that right now, but you have to amend your declaration on this topic in a condo, which, even though I told you earlier, the condo statute is 80% to amend, it's 60% for this one topic. So when we amend bylaws for communities, we usually do a spot amendment on the declaration. They're both the same vote. It is not an HOA case, by the way, but the articles in here, in our opinion as well, I believe the law is still easily applicable to an HOA, not the statute, but the case. And the case stands for the proposition, you better have the authority to do so, to take it away before you do it. And if a client has the right to take it away, but no finding in it, or no ability to hold a hearing, I tell them to follow 11103 of the Condo Act. And by the way, if a community had the right to fine before, but didn't explain the procedures before this new law just came out, I said, follow the Condo Act. Why? Because the judges know it and the legislature approved it. So if an HOA is a similar entity to a condo, follow the Condo Act. But now we don't have to. Now we have it in the HOA Act. Does that answer that? Okay. Go to, if in the audience or in watching, page 2 of the outline on collections and page 3. Just look at page 3 for a second. You'll see a flow chart. It's this big packet. So I got a cover page, and then I have a little outline I'm going to follow in a second, and then I have a flow chart. Maybe the copy didn't get it. Yes. So this flow chart is actually something I use to train my paralegals, but you can follow it. But let's go back to page 2. Just want to give you the big picture here. It's really easy. You have the right to lien. That's what you should always do in the beginning. It preserves, protects your values, the property and the money you owed. They can't sell without getting you paid. They can't refinance without you getting paid. If they die, the lien gets you paid. And most of the time in a bankruptcy, you're still protected unless they move to strip the lien and the value of the liens on the property is greater than the debt, in which case you could be screwed. Post-judgment collections, how, if they don't voluntarily work with you, how do you get it? You're garnishing wages, bank accounts, taking their house, their diamond ring, whatever you want. Number 4, if these earlier processes don't work and the liening and the suing doesn't work, you got to give your authority the authority to go for the jugular and foreclose. Like I said earlier, you do not want to be in a lineal situation. That debt is going to grow from 10,000 to 15 to 20 to 30. And it's going to keep going because they're never going to be able to pay. I don't care if you have to waste $5,000 on an attorney to get rid of them. It's a total loss because you're going to have a new owner and it starts paying. So you got to get that in your head. Bankruptcy is very complicated. I'm going through this really fast because I got like 5 minutes left. But if somebody files a Chapter 7, basic discharge, they're getting rid of all their debt. They file it on May 1st. They have to start paying the assessments from that point forward. The rest is written off, other than what's secured by the lien, but I can't go after them personally for that. You can only get it in refi, sale, or foreclosure. There is no stay in a 7. That's what sub A says. If Peggy files bankruptcy in a 13, which is under sub B, I cannot go after her or her spouse anymore during the bankruptcy because they're supposed to pay post petition, and everything up to that point in time is rolled into a big payment plan back to all the debtors, including a community. She's got an obligation to stay current on those post petition assessments, or I have the right to try to mess her up in her bankruptcy. Back to some things we talked about. Number 6, if you're all having problems with delinquencies, adopt a collection policy. B, publish delinquents potentially. Be careful. Talk to your attorney if you're thinking about doing that. Oh, I thought I was going to change this. Okay, revoke parking privileges, revoke pool privileges. Again, in accordance with the new statute for condos or the case law for HOAs. You've always had the right to revoke voting. So they cannot vote on amendments or elections if somebody has a lien on their property. By statute in the Condo Act, most HOAs say 60 days or more delinquent, you lose the right to vote. Keep in mind when you're talking amendments though, it's 90 days under the new statute, but anything else is usually 60. You can adopt a lease addendum with private garnishment rights. So oftentimes we have Peggy who rents to Theresa and she's making all the money on Theresa, but Peggy's not paying the community. How annoying is that? So we have an agreement. Everybody require all people who have leases in the community to adopt a lease addendum, which is a contract between Peggy, the owner, the landlord, and the community. And it says, if she's paying her and Peggy's not paying us, I have the right to garnish her wages without even a judgment potentially, by her consent in the agreement. That's a cool little tool. I don't use it too much, but I use it to threaten to get them to work together to pay the community. I also sometimes deny people's applications for whatever architectural approval they want because they're not paying. So how annoying is it the guy owes you $30,000, but then he wants to put a $30,000 deck in and he doesn't pay you the money? That's ridiculous. By the way, I did write this outline earlier, a long time ago when I taught a class for CAI. I might be a little careful with G in light of the ruling in Elberton because they might rule that you cannot do that by rule and it has to be in the declaration or bylaws. So going back to my form documents, I write this. I'm sorry, by the way, these are not forms. These are my best documents for each community because they really do. When you amend these, the key is understanding the law and how to make it better and pull together what's in your original documents and get the client what they really want. But 80% does flow, to be frank, from community to community with the basic core of the law. Almost done. Sorry, I just want to read this one paragraph. ACC, here we go. All right, so this I know is legal. Rule and reg might not be. Regardless of the architectural merits of any request for modification or alteration to a unit, this was a condo set, no consent of the board or the ACC will be granted to any unit or such modification or alteration so long as there remains any past due balance owed to the condominium unit owner or the blah, 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 blah. So you can see what I'm saying. So I'm putting it right in the covenants, giving the board the power to screw the guy who wants the new deck till he pays the community. I really like that. In crazy cases, cutting off water, electricity, we did this at Lynn Hill before they collapsed when I was involved. So you got to be really careful. This is crazy situations. If you really have that big of a problem, you definitely need to get your lawyer involved and maybe even the county, wherever you are, or city. Let's skip number 7. That's really legal stuff. And 8 doesn't really matter. It's just bank stuff. So, and if you flip the page, you'll see the outline, and I'm done after this. So you're sending a demand letter, you're waiting, then you're leaning. If the liens don't work, you split and you go down the foreclosure route on the right, or you sue on the left. I generally don't head down that foreclosure route unless there's really a lot of money owed. And it's just a nice little flow chart that you can follow through. I would, so really good bedtime reading here. And any of you really interested in collections, come to the class. Teresa, when is that?
June 7th, 6 to 8.
June 7th, one of 2 really great attorneys. Who's the other one? Mike Neal coming?
Yes.
So one guy in my firm and another one of our colleagues, Mike Neal, will be teaching that class. And that'll be more focused on that topic. And that's all I have. Any other questions? Got one here and then I'm done.
I have 2 over here.
2 over here. So we got 3 more questions and I'll be wrapping up. And just to let everybody know, the other 2 topics really have nothing to do with me. So Teresa's excused me to go have some fun in this pretty day. So if there's any other questions for a free lawyer, let's do it now and I'm wrapping up. What are the questions?
So if a reserve study was not properly developed, does the board, our board did not appropriately fund the reserves for the incorrect study. Can Craig confirm that we have 3 years to fund the reserve, even if our guiding documents limit our fee increase to 20%? I think it will take us more than 3 years to fund reserves for incorrect study.
Yeah, so that's a great question and I missed saying that. Okay, so she asked about the reserve study and well, let me hit one issue at a time. She asked about the issue with if you need more money, how do you get it? And they have a cap. I forgot to mention that. That's a great question. So most HOAs or a lot of them have caps. You can't increase more than 5% or 10% without a 2/3 vote of the owner. Same thing with special assessments. The statute overrides that. You do not need to get the vote of the owners to replenish your reserves. The other part kind of implied that the reserve report wasn't done right before. And do you really need to, do you still have that 3 years to replenish? What I would advise that person is to get a new reserve study immediately and rely upon that, not use the old one that's wrong. And if you have a reserve guy you work with that's reputable, you can actually go to them and have them update it. And you might want to use that because what was done before might be inaccurate. And I don't want boards playing with this, by the way. Like you get a reserve report and it says you need 100,000 for the roof, but you already replaced the roof and you don't know what the new amount should be to replace it down the road. I don't want the board messing with that and making arguments and getting themselves in trouble. I want you to go back to the reserve guy and say, this is not correct anymore. This is not correct. Please update it. Because you could end up in court on these issues now with this new statute. It's very serious stuff. And I'm telling you right now, if people don't do what they're supposed to do, and then some massive special assessments come down the road to the owners because things weren't done right, though, that's where you're going to see lawsuits against the boards. It's going to happen. So does that answer that person's question? Second question.
Question, does the HOA need anonymous vote or not when voting via email?
Does the HOA need anonymous voting when voting by email? So you mean the board? Is that, they mean
So
the
the board is
or
voting via email, does it need all 5 board members or 7 board members to vote via email in order for that?
Well, when the board, there's no way board members can vote anonymously. Is that what he's asking?
Yeah.
Yeah, you cannot have board members vote anonymously. And you really can't have owners vote anonymously unless it's an election. And some communities' documents allow for secret ballots. But personally, I don't really like secret ballots because at the end of the day, I believe if somebody made a document request under 11B112 or 11116 of the Condominium Act on a controversial election issue.
Unanimous, is what you're saying, not anonymous.
Oh,
Unanimous.
I believe the 5 of them should agree to discuss the issue by email unanimously. That will minimize any chance of challenge. But then I want at least 3 of the 5, assuming it's a 5-member board, to make the decision, to be able to make a decision, whatever it is. So if you have a situation with 4 who are willing to vote by email and 1 who's not, that could create an issue. Is that what he's asking?
Yes.
Okay, well, I mean, there's no exact answer, but
So
I would prefer to have all 5 agree. I would. We got a phone ringing. Sorry.
So sorry.
I prefer to have all, and it's stressed in the article. I prefer to have all 5 agree to make the decision by email. But again, like I had the situation with the jerk. There's no way he's going to agree to anything. And in fact, we're excluding him from everything because he's such a jerk anyways. We're talking about him in emails and meetings. I don't know what else to do. Could he make an argument that we're excluding him? We shouldn't? Sure, I don't care. Let him take me to court. You know, whatever. Somebody else had a question.
It's a rather broad question, but I think it's applicable to everybody. We all have fiduciary responsibilities.
Yes.
Obligations. It's to the corporation or to the shareholder. In other words, is it to the association?
Yeah.
Or to the unit?
Well,
owner? Because if you have some board members sympathetic or empathetic to a unit owner and they're inclined to prefer to lean that way in a voting situation.
Mhm.
Our obligation is to the entire association or corporation.
So, kind of a tricky little question. I don't want to get lost in semantics. At the end of the day, you are appointed by the unit owners and you therefore have a fiduciary duty to enforce the covenants pursuant to the power they gave you. But everything you're doing is based on enforcing the documents for the community. Does that help answer that question? Your duty is to the owners.
In the
As a
plural, not to a specific owner.
Oh, so I wanted to cover the broad part first, then get to the specific. Once you get on the board, your friend is not your friend anymore. You need to do what is right for the community, period. And if you're voting based on your individual thoughts, personal, I should say, that's really not appropriate. So that's why I get to treating, when Theresa was over there, and Peggy differently. The only reason you would do it is because of your personal thoughts for whatever, animosity towards one liking the other. Again, treat everybody equal. They can be your friend, but when your hat is on as a board member, they're not your friend. You got to do your job. And it can be very difficult when you're talking about, let's just say your best friend put up a fence without permission. And you know the attorney's going to go for the jugular and force them to remove it and or spend $10,000 to fight me. I don't care. You better do it or you're in trouble because you're breaching your duty if you don't do that.
Are there any new laws pertaining to Airbnbs?
No, but we amend the community's documents all the time to prohibit Airbnb type situations. That's what I was doing last Saturday, by the way. Because because of COVID, there's tons of community, well, more particularly Deep Creek and other beach resorts where people they don't want to travel. So they're all going there. So then you got these kids or other families renting these homes and then throwing huge parties and annoying everybody in communities where it used to be quiet. So here's what I usually put in my leasing. Sometimes I outright ban leasing, by the way, altogether, because that's a big whole nother topic. But something like this is what I write. Not something, this is what I have in my documents. No unit owner may lease his unit for transient or hotel purposes, including without limitation, Airbnb or other short-term rental operations. And then I go on to a bunch of other stuff. So it's not a statute, it's a rule. And then despite by the way, I've gone up against Airbnb and Vero and the other ones before. If you have these provisions and they're doing it, you need to report to them and they will shut them down. And if they don't, you threaten to sue Airbnb and the owner, and trust me, it works. I haven't had to sue yet, but I can't tell you, probably had 100 cases.
Craig, we have like 4 more and that's it.
We're gonna take no more Zoom questions. We'll take these last couple.
Can assessments be tax deductible?
Don't believe so, but you'd have to ask your personal accountant.
Okay, and then can community
On
boards?
your personal tax return?
I don't think so, because I've paid in my community.
Only if you're renting that property.
Wait a minute.
If you're doing a Schedule E, yes. But again, if renting is prohibited, you shouldn't be doing it. So it's kind of a circular question.
But you said assessments, right?
Now, you said can assessments
HOA
be tax
fees. If
I
deductible?
don't-
you're renting, yes, but not on your personal.
Oh, you mean because you have a business entity?
Correct.
Yeah, that's a good point. So if it's a rental business, and that's, that might be I don't even know if the assessments are.
Yes.
Yeah, okay, all right. I'm not an accountant member, stopped at intermediate.
Okay. Can community boards partner with,
Expenses.
Can community boards what?
Housing expenses.
can community boards partner with outside entities to purchase property that will benefit the community?
Can a board work with somebody outside to purchase property? Well, that really wouldn't, I don't know. That's an interesting issue. I don't even know if maybe is my answer. You'd have to look at the charter and the articles of incorporation for an HOA, what powers and duty a board had. What do you mean? Like, so you'd have a lot next to you and you want to purchase it and turn it into
Yes.
common area? I mean, I guess it's possible.
Or it's already an amenity in this community where they have a pool or clubhouse and it belongs to another party and they want to purchase it.
I mean, possibly. So what I did in one interesting community in Prince George's County, there's got to be a way to do it. Yes. I haven't figured out exactly how, but like we had an entity where a master association was created that maintained the pool and the tennis court and a condo. And it was kind of stupid because they really looked like one physically to everybody. And then they had two boards, two managers. We were the attorney for both, insurance policy and everything. And we said, this is stupid. So we dissolved the master HOA sort of thing. And then it was a condo was the other entity. And we deeded the pool and the tennis courts to the condo as an asset. So it's not a common element or a limited common element or a unit of a condo. It's an asset that they own. And so we did that.
I did that with the golf course.
Yeah.
And Beltsville Silver Spring.
So you probably could do it, but that's something I would want to do really carefully, do it out in the open, make sure it's okay and see if anybody's going to challenge you. So you can
And
try
update
to
your
avoid
reserve
court. What?
Update your reserve study.
Yeah, that definitely is going to be an asset.
All right, if a homeowner has a lien on his house and he sells his house, how does the HOA get the money from the delinquent account after the house is sold?
You get paid when the house is sold because when you're selling, the title company is going to pull title. They're going to see the lien. They're going to email Craig. I'm going to kick it to my collections people and they're going to give payoff because the title company can't transfer clear title to the purchaser without paying a lien. And if they don't, I have the right to foreclose on the new owner and I'm in priority over the mortgage.
Yep.
Is there?
Is that it?
The last question here is, a board member says they gave another board member their proxy to vote. Yep,
No.
he's already shaking his head, you guys.
Illegal.
Illegal.
Proxies are okay for unit owners for elections and amendment issues and things like that, but board members cannot give their proxy. The board member must be present in person or by proxy. I'm sorry, in person or virtual under the new virtual meeting laws and present at the meeting. So remember, every decision of a board is by a majority of a quorum. So it's not a majority of the number of board members. So if you only have 4 show up out of 5, you need 3. If you have a 7-member board, you must have 4 and then 3 of the 4. So you cannot proxy as a board member. You must be there.
Perfect. That's all. Thank you.
Wow.
Let's give Craig a round of applause. That was awesome.